Afternoon, everyone. I'm greeting from Maharashtra National Law University, Mumbai, Center for Arbitration and Research. It gives me immense pleasure to invite you all for the 8th Distinguished Lecture on International Arbitration by Professor Gary Bond. For an introduction, MNLU is one of the foremost national law universities situated in economic capital of India. As Chief Justice of India, Dr. D.Y. Chandrachud, the Chancellor, and Dr. Dilip Uke as the Vice Chancellor of the university. The university also offers various courses, including integrated programs in BA, LLB, LLM, and BA, and also offers PG diploma programs in arbitration and mediation. Center for Arbitration and Research was established in 2019. Since then, our center has taken great strides in the field of arbitration and mediation. Some of the important work of CAR, among others, include survey report on third-party funding, guide on virtual arbitration, handbook on international arbitration, and primer on aviation and space arbitration. The distinguished lecture series on international arbitration was started by Professor Chirag Balyan as an initiative of Indian Review of International Arbitration. Two lectures are scheduled every year. The aim is to invite distinguished arbitration practitioners to speak on contemporary issues in arbitration. And we have several eminent arbitrators on our advisory board of our journals, such as George Bowman, Gaurav Banerjee, Mark Fieldman, Julian Chase, Nisha Barusi, and Philippe Clifford. Our previous lectures of this program were delivered by Professor Lawrence Boison, Julian Chase, Jeffrey Winsmer, Stephen Kroll, and Kaj Hober. And now, joining this distinguished lecture, we have Professor Gary Vaughan. Professor Gary is a globally renowned expert in the field of international commercial arbitration and litigation. He serves as the chair of International Arbitration Practice Group at Wilmer Cutler, Pickering Hale, and Dorr LLP, and is universally acknowledged as the world's leading authority in his domain. He has served as counsel in over 675 arbitrations, including some of the largest and most significant cases in ICC and an ad hoc history, and he has also acted as an arbitrator in more than 250 institutional ad hoc arbitrations. Beyond his remarkable practice, Professor Vaughan has made invaluable academic contributions as well. He is the author of International Commercial Arbitration, the leading treatise in the field, which has earned high accolades such as American Society of International Law's Certificate of Merit for High Technical Craftsmanship. Professor Bond's impact on legal education is profound. He holds honorary professorships at the University of St. Gallen in Switzerland and Tsinghua University in Beijing, and regularly imparts his expertise at law schools across Europe, Asia, and America. Not only that, he is a former president of the Singapore International Arbitration Center, Court of Arbitration, and currently serves on the International Advisory Board of Hong Kong International Arbitration Center, the International Arbitration Committee of Korean Commercial Arbitral Board, and the Global Advisory Board of the New York International Arbitration Center. Among his numerous achievements, Professor Bond has also received the Global Arbitration Review Inaugural Advocate of the Year Award, the Client Choice Award for Best International Arbitration Practitioner, the Best Lawyers London Arbitration Lawyer of the Year Award. He is one of the only two practitioners globally to achieve status of international arbitration in the Chambers Guides, and in 2018, Chambers recognized him for his outstanding contribution to legal profession, describing him as the foremost authority on international arbitration and litigation in a class of his own. In addition to his legal scholarship, Professor Bond is also author of The File, a best-selling spy thriller showcasing his versatility and native talent. We are incredibly fortunate to have Professor Gary Vaughan with us today, and his vast knowledge, experience, and insights are really invaluable to us. And now, without further ado, I would like to welcome Professor Gary Vaughan to speak.
Thank you, Professor Bond. We can't wait to hear you. Just one word, uh, entire introduction. He's the preeminent authority on arbitration, and he's most humble person with which our center has associated. Thank you so much, sir. We are looking forward to hear from you.
No, thank you very much. And as discussed, it would be very helpful if someone could share the slides with the group.
I'll be doing that.
That's lovely. And I wanted to express my personal thanks as well to both you personally and to the university for inviting me to be with you, even if only virtually today. Many of these lectures, these keynote addresses have very serious aspirations. They endeavor to bring together, to synthesize under one common theme a number of disparate developments. I have no such aspirations. I don't pretend in this presentation to have a grand theme or an overarching theory. Instead, this talk is a little bit like the applications that seem to rule at least some of our lives in the 21st century. It's a review of recent developments in international arbitration with an invitation to either swipe left or swipe right on the profiles of the particular developments that I'll touch on. If, of course, you swipe right on one of these developments, it means you approve of it, you want it in your future. If, on the other hand, you swipe left, you're rejecting it. You don't want to make a connection with that particular development. You don't want it in your future. And with that background, perhaps moving to the next slide, and just reminding all of the participants about how the swiping works, we can begin looking at the various developments, the profiles that are available for us to swipe. And as I go through them, you also should be thinking for yourselves which way you would swipe, whether you want this development or the idea that's reflected in this development in your international arbitration life or not. I thought I would begin with the next slide somewhere close to home, a case that I'm sure many of you know better than I do. We can start with the three-judge bench of the Indian Supreme Court in MNLU Global. It involved an issue that, although it arose in India, is quite similar to issues that arise in countless jurisdictions around the world, whether under the UNCITRAL model law and international commercial arbitration or otherwise. The issue was, is there a valid agreement to arbitrate where the underlying contract itself is invalid and at least arguably null and void? In this case, it was because the agreement hadn't been stamped as required or hadn't been sufficiently stamped. The three-judge bench concluded that the arbitration agreement, of course, being a separable and autonomous agreement, notwithstanding being one clause in the underlying contract, was nonetheless valid, even in circumstances where the underlying contract was null and void. I think for this one, most of us, I certainly would swipe right. The three-judge bench of the Indian Supreme Court correctly applied the separability principle, the separability doctrine, and gave effect to the separable arbitration agreement. And the next slide, though, suggests how things might change in the world. A five-judge bench of the Indian Supreme Court reached the opposite conclusion, adopting the at least superficially attractive notion that if the underlying contract is null and void, then the arbitration clause, which is just one provision in that contract, also must be null and void. Swipe left for that, though. The five-judge bench was out of step with decisions both in India but also all around the world applying the separability doctrine. The good news, moving on to this slide, is that shortly thereafter, a seven-judge bench of the Indian Supreme Court went back to where the three-judge panel began, concluding that the arbitration clause, even though the unstamped or inadequately stamped underlying contract was null and void. The separable arbitration agreement was valid. Swipe right again on that decision for the same reason that we swiped right on the 3-judge decision. Moving away from India to the next slide, a perennial issue in both the United Kingdom, where I am at the moment, and also in many other jurisdictions, the law governing the arbitration agreement, the separable arbitration agreement, as we know from the Indian case that we just looked at. The question being, what law governs the arbitration agreement? In many circumstances, English courts have held historically that the law governing the arbitration agreement is the law that the parties have chosen to govern the underlying contract. And in a well-known case, Kebabji versus Kaut Food Group, the UK Supreme Court applied that principle to deny recognition of an award, an ICC arbitral award made in Paris, against a non-signatory. The English court concluded that the arbitration clause in that case, notwithstanding the fact that Paris, France, was the seat of the arbitration agreement was governed by the same law as the underlying contract because of the party's choice of law clause in the underlying contract. That choice of law clause selected English law, and applying English law, the UK Supreme Court concluded that the non-signatory party wasn't bound by the arbitration agreement, contrary to what the arbitral tribunal had concluded, and therefore denied recognition of the award. Swipe left. It does not make sense to extend the general choice of law clause in the underlying contract to the separable arbitration clause. That clause has a much closer connection to the arbitral seat than it does to the substantive law governing the party's underlying contract. And courts in many jurisdictions around the world have properly reached that conclusion. The UK Supreme Court's decision is therefore wrong. Swipe left. But fortunately, move to the next slide, where the French Court of Cassation reached the opposite result in the same case as the UK Supreme Court, concluding that because the arbitration was seated in Paris, the law applicable to the arbitration agreement wasn't that of the underlying contract, but rather was that of France. France applying its notion of international arbitration law to the substantive validity and to the question of non-signatory status of under the arbitration agreement. Swipe right. That is the correct approach to selecting the law applicable to an international arbitration agreement, absent specific provision to the contrary in a choice of law clause in the underlying contract. The better view is to apply the law selected by the arbitral seat as opposed to the law governing the underlying contract. Swipe right for the French Court of Cassation's application of the correct choice of law principle in these circumstances. Moving to the next slide, even the UK Supreme Court may ultimately get to the correct result, although recent political developments in England may shed some doubt on this. The UK Law Commission examined the same issue presented in the Kebabji case that we have just looked at, namely the question of what law applies to an international arbitration agreement. It recommended, as you can see on the slide, that the English Arbitration Act be amended to provide that an international arbitration agreement is presumptively governed by the law of the seat, save where the parties expressly agree otherwise. And quite clear from the Law Commission's report that the express agreement to the contrary isn't satisfied by a general choice of law clause in the underlying contract. One requires a specific choice of law with respect to the arbitration agreement itself. The Law Commission proposal was reflected in legislation pending before the UK Parliament, and recent political developments potentially derailed what appeared to be a fairly smooth approval process. All parties supported the proposed legislative amendments to the Arbitration Act, and hopefully, swipe right, hopefully that legislation will in due course be enacted, bringing the UK into line with both the Court of Cassation in France, but the better reasoned decisions in most other jurisdictions. Swipe right for the Law Commission and hopefully Parliament. Next slide, please. An interesting series of cases involving the DIFC LCIA. As the participants will well know, the DIFC, Dubai International Financial Center, LCIA, London Court of International Arbitration, was a joint venture of sorts between the DIFC on the one hand and LCIA on the other hand. It was a successful Middle Eastern arbitral institution. It had probably the largest caseload in the Middle East and was well appreciated by international parties, international investors, including parties from India. Frequently, DIFC LCIA arbitrations were seated in the Dubai International Financial Center, but they could also be seated elsewhere. Notwithstanding its popularity and the frequent appearance of DIFC LCIA arbitration clauses incorporating the DIFC LCIA arbitration rules into arbitration agreements, the ruler of Dubai saw fit to terminate relatively abruptly the existence of this institution, the DIFC LCIA. He did so by decree, which at the same time purported to transfer all the responsibilities and authority of the DIFC LCIA to an already existing Dubai arbitral institution, DIAC, the Dubai International Arbitration Center. And that action caused some uncertainty, both with respect to pending arbitrations. I won't dwell on that, but more importantly, with respect to the numerous arbitration agreements that existed in contracts that had been signed in the years prior to the shuttering of the DIFC LCIA. The case you see on the slide, Baker Hughes versus Dynamic Industries, was one such case. The contract between the parties had a DIFC LCIA clause in it, and one party, the US party, Baker Hughes, sought to litigate rather than to arbitrate its dispute with its counterparty, and it did so by initiating litigation in the southern part of the United States, Louisiana. And the issue before the Louisiana Court of First Instance was whether or not the parties were obliged to arbitrate. Baker Hughes, the party which wished to litigate, argued that the arbitration agreement was invalid. It did so on the basis that it had agreed to arbitrate under the DIFC LCIA rules, that there was no more DIFC LCIA, that institution having been terminated or shuttered by the local ruler, and in the absence of the arbitral institution under whose rules it had agreed to arbitrate, it was no longer obligated to arbitrate. This case presents a quandary, as sometimes these applications may present for their users. Should one swipe left or should one swipe right? Disapproving on the one hand or approving on the other hand what it was that the court did. What the court did was to accept Baker Hughes' argument. It concluded that in fact there was no valid arbitration agreement because there was no DIFC LCIA anymore before which the parties could arbitrate. One is tempted to swipe right, agreeing with that conclusion. Pretty clearly, the DIFC LCIA didn't exist anymore. If we could just stay on the previous slide, I know I'm going on at length about this, but it still has a couple points to make. And in that sense, requiring Baker Hughes or any party to arbitrate when the arbitration agreement faces significantly changed circumstances would at least arguably be wrong. The non-US party in this case argued, however, that the arbitration agreement remained valid by virtue of the Dubai ruler's decree, which, in addition to getting rid of the DIFC-LCIA, replaced it with the Dubai International Arbitration Center. The court rejected that argument. The court concluded that it was for the parties to agree before whom they would arbitrate, that they had specifically not agreed to arbitrate before the DIAC, which they could have chosen because it was in existence, but they hadn't. And as a consequence, the Dubai ruler's decree couldn't impose upon the parties an obligation to participate in a DIAC arbitration, which the parties had never agreed to. Still, although one perhaps is beginning to have some second thoughts here, still swipe right. The Dubai ruler's decree oughtn't impose upon the parties an obligation to arbitrate, which they not only never accepted, but which in fact they specifically chose not to avail themselves of. But before we move on, we can move on to the next slide because it involves a similar issue. But before we close out this particular issue, before we move on to other profiles, it's worth noting that other courts, the Singapore High Court as well, reached a very similar conclusion. In the case of the Singapore decision, the court reasoned that the parties' agreement had been frustrated, and had the objections to arbitral jurisdiction not been waived as they were in that case, it would not have required the parties to arbitrate, and instead, like the Louisiana court, would have permitted litigation or would have declined to recognize the award that was involved in that case. And so the Louisiana court, the Singapore court's refusal in principle to require parties to arbitrate under the replacement DIAC institution tempts one to swipe right. But I would suggest we ought to think hard before we really do that. And the reason is as follows. It is certainly true that the parties' agreement to arbitrate before the DIFC-LCIA is frustrated. One can no longer regard that as a valid obligation. However, that doesn't mean that there is no agreement at all to arbitrate. The parties' agreement to arbitrate before the DIFC-LCIA may be frustrated, but they continue to have agreed to arbitrate. And that agreement, once one blue pencils or red pencils out the selection of the now non-existent DIFC-LCIA, could very well continue to bind the parties. And I would suggest that what one must do in these circumstances is to consider carefully the other aspects of the arbitration agreement, if we could go back for just one second. And in particular, what was the arbitral seat? If the arbitration was, for example, as often is the case, seated in the DIFC, and in those circumstances, I would suggest the proper approach is to look to what the law of the arbitral seat, in that case, the applicable arbitration legislation in Dubai and the DIFC, would provide in circumstances where the parties have agreed to an ad hoc arbitration. I would suggest that that would result in the DIFC being an appointing authority, and I would suggest that that would be an entirely reasonable approach towards circumstances where the parties' underlying arbitration agreement under the DIFC-LCIA rules has been frustrated, but the agreement to arbitrate nonetheless can be preserved with the DIFC itself acting as appointing authority. I think that is preferable to imposing upon the parties the obligation to arbitrate under institutional rules, which they never accepted. I would suggest, though, that there is a more serious counter-argument than that recognized by the Louisiana or the Singapore courts, where you have an arbitration seated in Dubai. In those circumstances, if one accepts that there remains an agreement to arbitrate with a gap, no selection of an arbitral institution, where should one look to fill that gap? One should most naturally look to the arbitral seat. And what does the law of the arbitral seat, if the parties have chosen Dubai, provide? It provides that the DIAC will succeed to the responsibilities of the ISCL-CIA. And in those circumstances, the parties can, in fact, be said to have agreed to a DIAC arbitration, even if at the time they didn't choose it specifically. They nonetheless selected an arbitral seat, and hence arbitration legislation, which, at least by the time their dispute arose, provided for a DIAC arbitration. I would readily confess that this is one where it's difficult to decide whether to swipe left or swipe right. But it is, in practical terms, an important issue that will no doubt continue to arise. It becomes, and I won't dwell further on this, it becomes even more complicated if one has seats outside of Dubai. But let's say goodbye to Dubai and move on to the rise of regional arbitration centers. The next slide. Historically, the ICC, the LCIA were preeminent arbitral institutions, but in recent years, other institutions have gained in popularity. This is on the current slide, an excerpt from the Queen Mary and White and Case annual International Arbitration Survey, which reflects the preferences, at least in 2021, of a number of users. The 5 most preferred arbitral institutions were, in descending order, the ICC, the SIAC, the Singapore International Arbitration Center, the Hong Kong Arbitral Institution, the LCIA, and CTAC. I think those numbers reflect the particular pool of participants that responded. I think they probably have a Southeast Asian leaning that wouldn't necessarily be reflected if one had, for example, Latin American or users from elsewhere. What I do think both this slide and also if we could move to the next slide shows, however, is the increasing diversity with respect to arbitral seats. These slides will be available to the participants if they wish, so that you can look at them in your own time. But I think the takeaway from this, but more importantly, the next slide, is that there's been a fair amount of movement in parties, typically commercial parties, but also state-owned entities, preferences with respect to arbitral seats. Historically, the selection was dominated very much by Switzerland and France. You can see that on the left-hand side of this graph back in the year 2000, 25 years or so ago, where each of Switzerland and France had roughly 25% of the market, so to speak, for international arbitral seats. Those numbers have declined quite significantly, particularly in the case of France. These are statistics based on ICC arbitrations, and so there's a bit of a bias towards both France and Switzerland, I would suggest, just like there was a bias in the Queen Mary study. But even with that bias, it shows a significant reduction in the preference for both France in particular, but also Switzerland, a significant increase in a number of other jurisdictions. You can see them down in the bottom part of the slide, where many arbitral seats have gone from 0 or not even being on the chart to fairly significant proportions, and in a higher diversity of different seats. the UAE, Qatar, Brazil, Singapore becoming significantly more popular, the UK holding steady, the United States increasing its share. And I do think when we come to look at this in 10 years, if I come back to speak to you again, we'll begin to see Mumbai and India appearing on this as the prevalence, the attractiveness of Indian arbitral institutions increases over time. What this does show, though, is that there is a broader diversity of choices that are available for commercial parties. If we can move to the next slide, please. This slide begins a series of slides that address a common issue that is both important and interesting. The case is called Noble Resources versus Xintai. It is a Shanghai appellate court decision. It's a little bit out of my time zone. It's from 2017, but still recent enough to be of interest. And it raises the general question of when can an award be annulled or denied recognition on the basis that the parties' agreed procedures were not complied with. That, of course, non-compliance with the parties' agreed arbitral procedures is a ground for non-recognition of an award under Article 5(1)(d) of the New York Convention, and it's also a basis for annulment under the model law, Article 34(2)(a)(4), if I recall correctly. In each case where the arbitral tribunal or the arbitral institution fails to comply with the procedures set out in the parties' arbitration agreement, an award might either be denied recognition or alternatively in the arbitral seat annulled. That was the basis of a decision by the Shanghai Appellate Court to deny recognition to an award that was made in Singapore under the SIC, Singapore International Arbitration Center's expedited arbitration rules. Those rules, the expedited arbitration rules, were adopted by SIC and equally by many other institutions, not verbatim identical, but very similar, in order to provide faster, more expeditious, cheaper dispute resolution for smaller value disputes. The rules vary somewhat from one institution to another, but the basic concept is that for small value disputes of less than a few $1,000,000, I think in Singapore's case, it's around $4 million US. I think with the ICC, it's around $2.5 million. An expedited procedure will be adopted. That expedited procedure will require the arbitral tribunal to make an award within 6 months and will also provide that the arbitral procedures can be fast track in the sense of dispensing in some cases with a hearing or permitting it to be virtual, not requiring as complete a reasoning or as significant a degree of scrutiny by the arbitral institution of the award that would otherwise apply. And very importantly, also providing for a sole arbitrator. And that last requirement or provision is necessary because it's very hard to have a fast track arbitration in 6 months or so. But it's especially hard to do that if you have a 3-person tribunal with 3 busy arbitrators or even not so busy arbitrators trying to coordinate their schedules with counsel and the like. And hence, virtually all expedited procedure rules contemplate a sole arbitrator as opposed to a 3-person tribunal. And that's what happened in the case of the SIC. The SIC appointed a sole arbitrator who quite diligently delivered her award within the 6-month time period. That award was against the Chinese respondent, and it was taken to China for recognition, where the Shanghai Appellate Court denied recognition. It did so on the basis that the parties' arbitration agreement provided for a 3-person tribunal, provided as some arbitration agreements do, that the number of arbitrators shall be 3. And according to the Shanghai court, one arbitrator, the sole arbitrator, doesn't equal 3 arbitrators, and therefore the parties' agreed procedures were not complied with. Swipe left on this decision. It's wrong. It may, at first glance, appear attractive, but it's not. The reason it's not is because the parties' arbitration agreement in these circumstances doesn't only provide for a 3-person arbitral tribunal. The SIC rules specifically address the constitution of a tribunal in circumstances where a small value dispute is involved, and the parties' arbitration agreement incorporated those SIC expedited procedure rules. There was therefore at a minimum a conflict or ambiguity in the parties' arbitration agreement. Which provision prevails? The provision for a 3-person tribunal or the provision for a fast-track arbitration in small value disputes with a sole arbitrator? In my view, there's no perfect answer to that question. Who knows exactly what the parties might or might not have agreed or intended in those circumstances. However, the arbitral institution who drafted the rules in question reached the conclusion that that ambiguity was best interpreted as permitting a sole arbitrator in small value disputes. That did not do away with the agreement on a 3-person tribunal. It left it intact, just for cases other than small value disputes, for larger value disputes. The arbitral institution's interpretation of its own rules would, in my view, be entitled to substantial deference. That would be particularly the case where the arbitration in question was seated in Singapore, and Singaporean courts had previously considered this precise issue and upheld the views of the Singapore International Arbitration Center. And in those circumstances where both the arbitral institution whose rules are being administered and the courts in the arbitral seat have reached the same conclusion about how to deal with an admittedly ambiguous or unclear or inconsistent agreement to arbitrate, their views ought to be given very substantial deference in a recognition proceeding before a foreign court. Chinese courts ought not to have sat in judgment and second-guessed the application of the SIC rules by that institution itself, with their decisions, the institution's decisions, being upheld by the Singaporean courts. Swipe left for Noble Resources and the Shanghai court's decision. The next slide presents a similar issue. In this case, it involved Singaporean courts, and is a case called ST Group versus Sanam Investments. There, again, as unfortunately is often the case, one had an ambiguous arbitration agreement, at least with respect to some aspect of the procedures. In this particular situation, that aspect was the selection of the arbitral seat. Everyone involved in the case agreed that the arbitration clause was poorly drafted in this respect. The clause didn't provide for a seat with the language that is familiar, providing simply, for example, the seat of the arbitration shall be Chennai, or the place of arbitration shall be New Delhi. It's very easy to pick a seat, but tragically, in this case, the parties didn't do so. What they did instead was to provide that the arbitration shall be conducted before a respected arbitral institution in Macau, which presented a host of interesting questions on which much ink could be spilled. Was Macau the seat? Was there a Macau arbitral institution that had been agreed to or selected? Was somewhere else the seat? The arbitral tribunal, after considering this issue, concluded that the arbitral seat was Singapore. And it did so on the basis that the parties had commenced, the claimant had commenced the arbitration under the SIC rules. It did so on the basis that SIC was the best, in its view, the best known arbitral institution in Macau, and hence SIC was the institutions selected by the parties' arbitration agreement. SIC accepted the arbitration, constituted a tribunal, which agreed that the parties' arbitration agreement had at least impliedly, if imperfectly, selected SIC arbitration, and also concluded that given that SIC arbitration had been selected, Singapore could properly be regarded as the arbitral seat, being the home base, the headquarters of SIC itself. That's not necessarily the perfect or only interpretation of the parties' arbitration agreement that could be adopted. The agreement was plainly ambiguous. And the Singapore High Court and then the Court of Appeal both agreed with that proposition. Like everyone else in the case, they concluded this is an ambiguous and equivocal arbitration agreement. But nonetheless, the Singapore courts took it upon themselves to reinterpret the arbitration agreement. And after, as I said previously, spilling much ink, concluded that actually the better view was that Macau was the arbitral seat, and the arbitration not having been conducted in Macau as the arbitral seat, therefore hadn't complied with the parties' agreed arbitral procedures. It didn't identify any particular difference between arbitration legislation in Macau and Singapore, but said it didn't need to in order to find that the award should be denied confirmation, because the selection of the seat is such a fundamentally important issue. If you get that wrong, you have per se failed to comply with the parties' agreed arbitral procedures. The swipe left again. The Singapore courts are wrong on this issue, where one has, as in the Noble Resources cases, an admittedly ambiguous, equivocal agreement to arbitrate, and the arbitral institution, or in this case, the arbitral tribunal, have done a reasonable job in interpreting that imperfect agreement. National courts, neither in annulment nor recognition actions, should second guess their decisions. In those cases, there's in all likelihood no right answer. The ambiguity can be resolved in different ways. And what's more important is that the parties' underlying objective of an efficient and expeditious dispute resolution process be respected. The likelihood that the national court, second guessing the arbitral tribunal, reaches the right rather than the wrong result is, I would suggest, low. The arbitral tribunal, the arbitral institution, know their rules better, know the circumstances of the arbitration better, are chosen by the parties to administer those rules and those procedures, and that choice ought to be respected, save where there's a clear departure from relatively clear language, which is not what one had in either Noble Resources or here in Sanam. And so, as I say, swipe left. Moving to the next slide, and then thinking we're probably going to need to be wrapping up at some point before too long. A US case involving a very similar issue reaches the right result. This case had the sort of provision that one encounters occasionally, if unfortunately, in arbitration agreements. It provided that in a case between A and B, should A commence the arbitration, it was required to do so seated in the hometown of B. Whereas if B commenced the arbitration, it would be required to do so in an arbitration seated in the home jurisdiction of A, a kind of tit for tat provision, presumably aimed at discouraging people from bringing arbitrations or litigations at all. Inevitably, these clauses cause more difficulty and disruption than any good thing. Inevitably, what happens is A commences an arbitration against B properly in B's hometown, and then B counterclaims. And that's what happened in this case, Bamberger Rosenheim versus OA Development. And the issue was, is B permitted to counterclaim in the arbitration seated in its own home jurisdiction, or must it instead commence a new arbitration in A's home jurisdiction, so that there will be two parallel arbitrations, one in A and one in B's home jurisdiction. The arbitral tribunal concluded that the counterclaims were properly brought in the arbitration in B's home jurisdiction, that a separate arbitration would be unduly expensive and not required by the parties' arbitration agreement. The losing party, in this case, sought to set aside the award in the United States on the basis that the parties agreed arbitral procedures had not been complied with because B had improperly been permitted to pursue counterclaims in its own home jurisdiction, an arbitration seated in its own home jurisdiction, and that wasn't what the parties had agreed. The U.S. court, quite properly, swipe right, rejected that argument. It recognized, I would suggest correctly, that there's actually no right answer to the question of what did the parties' arbitration agreement mean. Who knows what the parties meant with respect to counterclaims when they put that peculiar provision in their agreement. Perhaps they meant for the counterclaims to be permitted. Perhaps they intended to require a separate arbitration. Perhaps, and most likely, they never even considered the issue. And in those circumstances, the better view is to defer to the arbitral tribunal's decision, whether it would be a decision to require the counterclaims to be brought separately in the new arbitration seated in A's home jurisdiction, or, as this tribunal concluded, permitting the counterclaims to be asserted in the same arbitration. What's important, again, I would suggest, swiping right with the American court, is that the parties' underlying objective of resolving their disputes expeditiously and efficiently be given effect. I think I'll do one more case, and then perhaps we can take a few moments for questions. This was a recent decision also from the United States that I think might cause at least some participants to question my previous swipe recommendations. It involved an arbitration seated in the United States, where the parties' arbitration agreement provided that each party shall pay its own costs of counsel. You can see that on the slide. It also, the parties' agreement also had in its substantive provisions a provision that said the arbitrator shall not award damages in excess of compensatory damages under this agreement. And the issue that arose, the interesting issue, several issues actually arose, but the interesting issue that arose in this case, American Zurich Insurance Company versus Sun Holdings, was the arbitral tribunal empowered to award costs, the legal costs of the arbitration, in favor of the prevailing and against the losing party. The arbitral tribunal did so. It concluded that the respondent in the arbitration was both liable substantively for the claimant's claims, but also that it was obligated to pay the legal costs in American terms, the attorney's fees incurred during the successful arbitration by the claimant. And that particular part of the decision was challenged in an action to set aside or vacate the arbitral award. The principal basis for the annulment application was the provision that I read out a few moments ago: each party shall pay its own costs of counsel. It was said that that provision had been disregarded by the arbitral tribunal. The U.S. court, the Seventh Circuit, rejected that argument, and I think many people would be inclined here to swipe right. One has to assess that argument against the background of what's called the American rule, in contrast to both Indian courts, I think, and certainly English and many other common law courts. In the United States, the prevailing party is, as a general rule, not entitled to recover its costs. The American rule provides that, come what may, with some very limited exceptions, the prevailing party is not entitled to recover its legal costs. Each party bears its own costs, and the provision in the parties' arbitration agreement, each party shall pay its own costs of counsel, I think needs to be seen in that context. despite that, the arbitral tribunal concluded that the legal costs were part of the compensatory damages that had been suffered by the prevailing party and awarded those costs. The Seventh Circuit upheld that decision, saying we will defer to the arbitral tribunal's interpretation of these provisions of the parties' arbitration agreement. That holding is consistent with the swipe recommendations that I made in Noble Resources and the Sanam case, deferring to the arbitral tribunal's interpretation of procedural aspects of the arbitration agreement. Nonetheless, where a arbitration agreement provides specifically each party shall pay its own costs of counsel, it does take some effort, and perhaps it's wrong to make that effort to ignore that provision and to conclude that in fact one party shall be required to pay the other party's costs of counsel, even when that party is the prevailing party. This case comes close to what I described previously as, in effect, the boundary for non-compliance with the parties' agreed arbitral procedures, where one has an unambiguous provision, an unequivocal provision addressing a particular issue, and either the arbitral institution or the arbitral tribunal disregards that provision. Perhaps the existence of both provisions, which you can see on the slide, creates enough of an ambiguity or inconsistency to justify the arbitral tribunal's decision. Perhaps the deference that I referred to previously is also sufficient. But it is a hard case to swipe too enthusiastically right on. But I think with that, I've overstayed my welcome, and I certainly want to leave room for questions if there are any for the audience.
Thank you, sir, for the excellent insights and sharing your opinion on some of the most crucial judgments. My question pertains to Baker Hughes, which you swiped right, and you mentioned that the court was right in not referring parties to arbitration. I want to understand the principle of separability in arbitration agreement. Could inconsistent part of the arbitration agreement, which is the known existence of an arbitral institution, would have been separated with the valid arbitration agreement? Could the court have interpreted that even though institutions have changed, even though there is an intent to arbitrate, and the fact that choice or the decision is not to be made by the institution, but by the court had the general power to appoint an arbitrator to further that intention, irrespective of the institution? What are your views, sir?
So I certainly agree that, and I think I suggested that the Baker Hughes, the general Baker Hughes problem is both an interesting and I think a difficult one. I certainly agree that when the parties selected arbitral institution, or for that matter, selected arbitrator, becomes unavailable, the arbitration agreement very often will nonetheless remain valid. The fact that one aspect of the arbitration agreement is frustrated or becomes non-existent doesn't, in my view, prevent the arbitration agreement nonetheless from continuing to both exist and to bind the parties. What one ought to consider doing in those circumstances is blue penciling out, disregarding the frustrated or no longer applicable part. Parties might, for example, agree to to arbitrate and select me as the arbitrator. But when a dispute arises, I might have a conflict and be unable to do that. Does that mean that the party's arbitration agreement is invalid? I would suggest not. It means that a different arbitrator needs to be selected. And I would suggest that in many cases, when institutions become non-existent, which happens with some frequency, the arbitration agreement nonetheless remains valid. It's just an arbitration agreement without the choice of an institution. And there are, national courts have reached that conclusion in a substantial number of cases. A similar kind of issue, I think it requires a little bit different analysis, but a similar kind of issue can arise when parties at the very outset choose an institution which doesn't exist. Parties do this usually out of sort of mistake or incompetence, perhaps. They specify the name of an institution which has never existed, and the question arises, is that a valid agreement to arbitrate? And again, national courts almost always have concluded the party's underlying objective here is to have their disputes resolved by arbitration. The particular means by which they chose to do that may be frustrated or not available, but nonetheless, they've agreed to arbitrate, and we will give effect to that agreement to arbitrate, even if we can't do it in exactly the way that they desire. And so I think that the Louisiana and the Singapore decisions are likely wrong in not referring the parties to arbitration. But the reason one might want to swipe right there is that the question was whether those parties should be referred to DIAC arbitration. And I think then it becomes a difficult question where what is being imposed by the local law, the ruler of Dubai, on the parties is a form of institutional arbitration which they specifically didn't choose, and where what is being done is giving effect to both the Dubai ruler's shuttering of the DIFC-LCIA and simultaneously his imposition of the DIAC. And I would suggest that is problematic. I think I would swipe left on that. But I do think, and imagine a case where an Indian party and a Dubai party agree to arbitrate under the DIFC-LCIA rules in Mumbai. Would it make sense to require the Indian party to arbitrate under the DIAC rules in those circumstances? One of the reasons the Indian party would have preferred the DIFC-LCIA to the DIAC back when the parties agreed to their arbitration agreement was exactly because it was a more international institution, and the Indian party didn't want to subject itself to the local DIAC arbitration institution. And then to give effect to the local Dubai rulers' imposition of the DIAC arbitration, after he has shuttered what the parties chose, I would suggest is problematic. I think, swipe left on that. I do think the case becomes more difficult if the Indian party, instead of agreeing on Mumbai as the arbitral seat, selects Dubai as the arbitral seat. And just one final thought on what I do think is a complicated issue. Note what might happen if we follow through, I think, the analysis that you and I have shared. Imagine the arbitration seated in Dubai. Imagine that we have shuttered the DIFC-LCIA. Imagine we have rejected the DIAC on the basis, as I've outlined, you shouldn't let the Dubai ruler impose a choice on the parties. What then? Arguably, what one has is an ad hoc arbitration clause seated in Dubai, onshore. And what does that mean about the appointing authority? What that means about the appointing authority is it would be the local Dubai courts. which is probably exactly the thing the Indian party most wanted to avoid. And therefore, I think one has to think very carefully about this issue and which way one wants to swipe. I do think one needs to have regard to where the seat is. I do think what the court, and this, my final thought on this, picking up on something in your question, I do think what is important here is for the court to have careful regard to what the party's intentions would have been. And careful regard in particular to, is there still a valid arbitration agreement? If so, what are its terms once we get rid of DIFC-LCIA? And I think there one has to look to the arbitral seat and other evidence of what their intentions were.
Thank you for that response. Just one slight question, you may say. Will it be an appropriate test for the court to say, let's compare the rules of the institutions, the erstwhile institution and the new institution, and can the court then say that no real prejudice is caused by the new rules? And that is...
Yeah, one could do that, but I would urge caution in doing that. I think what one would see there would be considerable similarity between the rules, but I think, I think this is the critical difference from the party's perspective. The individuals, the officers that would be making the appointment, even under rules which are very similar, are different. And that is in particular why foreign parties, international parties, preferred the DIFC-LCIA rules to the DIAC rules. The rules might look very similar, but the appointment practices and the individuals selected as arbitrators between the two institutions would be materially different. And I think that is where a party would say it suffered prejudice.
Right. Sir, if your time permits, can I take one or two questions from the chat box?
Why not? We're all together. Let's do it.
Yeah. Let's look at this issue wherein Anushka talks about Indian Supreme Court judgment of Cox and King, wherein they're talking about inclusion of known signatories.
The group of companies.
Jurisprudential, where is concept of consent going on in arbitration?
So Cox and King is a very interesting case. I think it's a constitutional bench of the Indian Supreme Court, which going a little bit against the trend in some other jurisdictions, adopted a version of the so-called group of companies doctrine or theory with respect to arbitration agreements. The Indian Supreme Court's decision is in contrast to, for example, English decisions where in a well-known case, Peterson Farms, the court said the group of companies doctrine is no part of English law. And Swiss courts have said similarly dismissive things about the group of companies doctrine. I actually think that the Indian Supreme Court, and in particular the way that it, I don't want to say restricted, but carefully formulated the group of companies doctrine, has the better of the argument between these national courts. The court focused very much on what the party's intentions were with respect to the extent to which a group of companies doctrine would be applied, the extent to which non-signatories could be bound by an agreement to arbitrate, even though they weren't formally party to the agreement. And I think that a restrained, a moderate application of the group of companies doctrine, in fact, gives better effect to the party's desires for efficient dispute resolution than a sort of absolutist black and white treatment of notions of privity in this context.
Thank you. Our next question is about related to noble resources, not about noble resources. It's about SIAC rules. You mentioned about expedited procedure, sole arbitrator, even if it goes against the wishes of the parties. So, do you think CX rules are too stringent, and there are some institutional rules which are very permissive about it? Especially the fact that CX does not, it does have monetary threshold, but still it does not distinguish between, say, for an example, there could be certain disputes of less monetary value, which could be complex dispute. I do understand president of CIAC has the discretion also in the subject matter. So how do you compare CIAC rule, or can they come in conflict in future with some countries like India?
Yeah, so the question is exactly correct. The SIC rules provide that expedited procedure rules are available, but not necessarily applicable when the monetary threshold is not exceeded. And in particular, what the SIC rules do is give the president discretion where, even though it's a small value dispute, it's either a very complicated small value dispute, those kinds of things can't exist, or it's a small value dispute monetarily, but it has substantial importance for other reasons. It interprets a provision that might have ongoing financial consequences. So although this particular dispute is small, it's a point of principle that is important. In those cases, the institution in the form of the president has the discretion not to require expedited procedure. I don't, and I think other institutional rules are also similar in this respect. There's also a kind of escape valve or safety net where if it turns out in the course of the expedited arbitration that the issues are too complicated or one party can't properly present its case, then the case can be taken off of expedited procedure. And that's not frequently used, but it's available as a kind of safety valve. In my view, with those safeguards, there oughtn't to be examples of conflicts between SIC or its rules on the one hand and national courts, be they Chinese or Indian or US or English or other. I think the SIC rules were adopted in response to users, businesses' desire for efficient resolution of their disputes. For smaller value disputes, businesses, they don't want to pay for gold-plated dispute resolution. They regard the smaller disputes a little bit like one regards traffic violations or something of the sort. They want those claims processed in an efficient way. They may win, they may lose, they may win some, they may lose some. What they want, though, is quick, efficient resolution of those disputes. And I think the SIC rules do a pretty good job in accomplishing that. They do it in a way that's quite similar to how other institutional rules operate. And I think the Noble Resources decision, which in my view, adopts a kind of absolutist reading of one part of the arbitration clause without deference to the institution or the courts in the seat, really frustrates both the institution's rules, but more importantly, the party's intent in agreeing to those rules. And so I would still swipe hard left.
Right. Thank you so much, sir, for being generous with your time. There are many more questions and they will never end. So, but I would like to take a pause here to the question and answer round. And from the bottom of my heart, I would like to sincerely thank to you to agreeing to do this lecture. I seriously enjoyed it, right? And I hope that most of our audiences enjoyed it. Thank you so much, sir. And I hope we could have you in Mumbai with us and have this one-to-one interaction in the future.
Thank you again personally for the invitation. It was, I hope it was of interest to all who participated, and I hope we can do it again in person. Thank you.
Yes.